Hello and welcome to Focus on Liberia. This is the FOL Justice Forum. My name is Dennis Jai and we are broadcasting from Atlanta, Georgia. In tonight's edition of the Justice Forum, we're going to be looking at the courts of Liberia. That's part one. And in part one, we're going to be looking at criminal courts and the civil courts. What constitute them? What are those courts? What are their responsibilities? What are their functions? And how are they different? My guest or the presenter for this show, I have Councillor Frederick A.B. Jayweh. Councillor, welcome to Focus on Liberia.
Thank you very much, Dennis. I'm happy to be here.
Great. In a minute, we're going to be joined by Councillor Kabineh Mohammed Janen. He's joining us from Monrovia. Councillor Jerome Verdier is not here tonight, and so we're going to get into it with the Justice Forum. We want you to invite your friend, share the show, and let's get started. Councillor, welcome. How is it there in Colorado, and what is the weather there?
So we have a sunny day today. It snowed on Thursday, Wednesday night into Thursday, but the day is very fine. We have a very nice sunny day out here.
Great. I know we started this, and this is the third show now on the FOL Justice Forum. So far, what are the feedback you're getting from since we started the show, and how are you doing? Doing this series, and what the feedback you're getting?
Well, I'm doing fine. People appearing to like the show. They are informing me from my end that we should continue with the discussion because it's helping to educate people who did not know about the court system and who might have been approaching the court with different lenses. So they thought that it's very informative and the thing is educative.
Great. Also, last week we delved into the civil law versus the criminal law. In 3 or 4 sentences, just give us a summary before we move on into today.
So the difference between the civil law and the criminal law system is that in the criminal law system, a defendant is presumed innocent until he or she is proven guilty. To start with, he or she could be arrested on a writ of arrest on an indictment to include a writ of arrest that brings him to the court. His liberty is restrained. In the civil case, that is not the situation. The writ of summons goes out with the complaint of a private party suing another private party, and you are allowed to come to court and answer within 10 days, or you could be placed on bail denial, or that a judgment by default, a judgment that could be entered against you for your failure to appear and provide evidence. But in that process, no one is arrested and no one is brought to court, and your liberty is not restrained.
And Councillor, when we say private party, I did not understand that when you said it before in last show. I thought private party was individual, but you are saying organization, companies, all these are considered private practice or private parties.
Yeah. So an individual person, you and me, will be considered as a private party. If I should sue you, I'm a private party. If you sue me, you are a private plaintiff. A corporation is seen in the eye of the law. Businesses, institutions, they are established as corporations are seen as individual in the eye of the law, and so they can become a plaintiff or a defendant. And on that note, they will be considered as private party. In a criminal case, being a civil case, the case can go on without the intervention of the government. It could be an individual suing Firestone. I could sue Firestone for something, and Firestone would be answering as a private party, a defendant in the case. Firestone could sue Lamco. Lamco would be answering as a private defendant, a private party. Firestone as a private party.
Thank you.
all the cases, the government of Liberia, unless there's a motion to intervene, the government will have little or no part to play at all.
Right. Thank you. Another difference there is in a criminal court or in a criminal case, we see that the government is kind of taking over the case. And we saw that with the government prosecutor, Serena Cephas, in the Ellis Cummings or ANC case. So that's a major difference. So that we don't see that as interfering, or we don't see that, oh, why the government doing it instead of the person who sued. So talk briefly about that major difference once more before we go into today.
So in a criminal case, the Republic of Liberia is known as the plaintiff. It is not a private case. It's not a private party situation. And because the government of Liberia is required to maintain law and order, the chief prosecutor or the prosecutors, the chief prosecutor is the Minister of Justice, this is followed by the Solicitor General, or any of the prosecuting attorneys at the Minister of Justice would take responsibility, represent the person who complained that a wrong has been committed against him or her, as if the government is the one against whom the crime is committed. That's the crime. The government is taking that position because law and order is supposed to be maintained by the government. So you see the Solicitor General in court in the case of Cummings. The Solicitor General is leading this case. So the Minister of Justice is referred to as the largest law office in Liberia to prosecute cases on behalf of the government of Liberia. There's nothing strange about that. There's nothing political about that. What is known is that the Solicitor General is playing the role. It could be the Minister of Justice. It could be the Deputy Minister for Litigation. It could be the Deputy Minister for Codification. Any of these people can come to court and prosecute, and must prosecute, not may prosecute, must prosecute all criminal cases. That's why you see the Solicitor General is in court. He's not the only person in court. There's a guy called Wisa is in court. Recently, if you follow up, you will find out that Councillor Wisa is leading the prosecution of the Secretary to the Senate, and this guy Wisner, who once worked in the Ellen Johnson State government. They are defendants. And Councillor Wisa is leading that trial. I also heard about Councillor Jerome Galawolo. I guess he's the son of the late Councillor Francis Galawolo. He's in other cases. So it is their right, it is their duty, it is their responsibility as prescribed by the law to represent the one who claims to be injured.
Thank you. So today we're going to be talking about the courts of Liberia Part 1. But before that, we always have our opening cases, right? So there are a few things I want us to talk about briefly to give us some enlightenment before we continue. It is reported in the paper that defense lawyers for the ANC, that's the Alternative National Congress, representing Mr. Cummings in this case, have requested for criminal investigation against state prosecutor led by the Solicitor General accused of extracting several text messages and exchanges submitted as evidence in the trial involving the alleged alteration of the CPP framework document. Councillor, what this is as you know already, the ALP brought the case against Mr. Cummings, and then in their private chat, their CPP chat room, the messages that were there were sent to the prosecutor during the discovery process. So what the ANC is saying that they did not give all the messages, they extracted some of those messages that made Mr. Cummings to look good or that made him appear innocent. They took those messages from there and gave the other messages. So because of that, they are bringing they want a criminal investigation against the Solicitor General for that. Councillor, first of all, talking about the text messages, should the text messages in that case be sent to the prosecutor in the discovery process?
So what is happening here is that it's an afterthought action by the Cummings lawyers. Why do I say that? So during the discovery process, we saw the prosecution asking Mr. Cummings to produce the original copy of the CPP document and all other documents. that might have been in the possession of Mr. Cummings. The prosecutors, because they represent the government of Liberia and they are the one that filed the lawsuit against Mr. Cummings, and the government of Liberia is a plaintiff, the discovery process requires that the state gave to the defense lawyers of Mr. Cummings all of the documents they had in their possession, the name of the witnesses that would testify on their behalf, and anybody else that they will subpoena to come to court and testify for them. During that process, we are informed that the email exchanges, the bulk of documents that were email exchanges, text messages, and
WhatsApp messages were all turned over to the state prosecutor in person of Councillor Sifa. And Councillor Sifa, during the discovery process, was required to turn those over to the lawyer for Mr. Cummings. The documents were turned over to under the discovery process. The text messages, WhatsApp messages, emails, and whatnot were all turned over to Councillor Cllr. And the discovery process ended. That process ended, and what is going on right now is a trial process. Now, let me tell you something. When the discovery process started, those documents that were handed over to Mr. Cummings' lawyer from the state, I heard Mr. Cummings' lawyer on Spoon Talk, the lead lawyer, Councillor Cllr, saying that the documents were voluminous, large. Some of them contain 150 pages, some of them contain 100 pages during the discovery process. And he had no time to examine them. And he did not, out of deference to the court, he did not want to waste the court time. Those documents were considered good. He passed on them. He agreed that they were a document that the prosecution was going to use. The first witness for the state is one Momo, I forgot his first name. Yeah.
He's the chairman of the ALP, has testified. And then when the witness testified, the prosecution, the state lawyer, the solicitor general, asked the witness to identify the documents that he had into his hand, confirm those documents, then asked the court to mark them, and they were marked, confirm and reconfirm. Now, this is a technical process. I explained that. Once a witness on the stand testify to, is this, you say you know the Liberian Constitution, Mr. Jayweh. When you see the Liberian Constitution, will you be able to recognize it? That's what the prosecution lawyer will ask you. And you will answer yes. And he will say, Mr. Jayweh, witness Jayweh, I pass you the document you identify as a Liberian Constitution. Please look at it and confirm whether in actuality this is the Liberian Constitution that you testify to. You have the court officer or the assistant clerk of court to pass the document over to you. When that document is passed over to you, it is not, the defense lawyer should be very, very attentive to be able to find out whether the document that will in fact pass on to you is the Liberian Constitution and not any other constitution. Because once you say yes, you see the document, say yes. And he will say, do you confirm and reconfirm this document? You also say yes. And the defense lawyer sit there and say nothing. That lawyer, the prosecution lawyer, will ask the court, Your Honor, at this stage, counsel for the state, ask the court to place a mark of identification on this document to be used into evidence during the finality of this case. When that request is made and the court grants that a mark, maybe P/1, P/2, A/3, something like that, placed on it, when the document is marked without you objecting, to say, wait a minute, Your Honor, counsel object to the document that is shown to the witness. it appears to us that the document that is shown to the witness are not the WhatsApp messages that we have in our possession. You must object before the counsel for the state asks for a mark of identification. If you don't, and that document is marked, you have lost the opportunity to contest the validity of that document. It goes down, if it's a circuit court trial, it goes down to the jury to establish whether, in fact, the document is sufficient to convict Mr. Cummings. In this case, it looks like, and it's not even looks like, it is that Mr. Cummings and his lawyer taking this case for granted. They look at the document. They allow the prosecution to ask the witness to confirm and reconfirm it. They allow the prosecution to move the court to mark the document, place mark of identification on the document. Their right to object to the document being used in evidence is waived. So what it claiming that there is a what do you call it? There is
extracted messages were extracted.
Yeah, there's some document extracted. The burden is on you, meaning to show that the document, the document that the claim were extracted were indeed extracted. So it's not, the burden is not on the state at all to say that document has been extracted. Mr. Cummings and his lawyer who are saying that the document were extracted, some of the WhatsApp messages were omitted. They were to examine the document when they were presented to the witness to confirm and reconfirm it. The failure.
Councillor,
yes.
Councillor, I thought that what they were doing now. You mean
no? What they're doing now, what the Cummings people are doing now, they're doing cross-examination. So I was
at what point were they supposed to object to this document?
So it's at a point when the witness testified and said, I guess what happened in this case is that the prosecution handled a bunch of documents to Theodore Momo, that's the guy name, to Mr. Theodore Momo, and say, Mr. Momo, there were text messages exchanged between Mr. Cummings and the political leader of the CPP. If you look at this document, are these the document he testified to? And Mr. Momo will say yes. He would then pass the document to Mr. Momo. At the stage of passing the document to Mr. Momo, the lawyer for Mr. Cummings should have objected on ground that the document that is presented to the witness in bulk contain extraction. The failure to do that, what happened is that all the witness identified all of the documents. The document were confirmed and reconfirmed. The state rested, meaning that the state had no more question for Mr. Theodore Momo. And then it was left with the government lawyer to come and do cross-examination, ask the witness, Mr. Witness, you said these documents are the document. But instead of doing that, apparently when they went back home, the following morning for them to come to start the cross-examination, after the document had been identified, marked, confirmed, and reconfirmed, and made part of the pieces of evidence for the court to pass on, because mind you, this case is before a magistrate. The magistrate is sitting down as a jury, meaning the trial of facts, and he is sitting down as the judge. He got the two roles, he playing them. Because this is a case, this is a court that does not entertain jury trial. So once the document was passed to them, they still had arrested evidence without witness. They're not asking him any more questions. They now pass it on to the lawyers of Mr. Cummings to come and question him as to whether what he said is truthful or not. It is not. At that stage, you cannot claim that a document was extracted.
Right. And so
if you did not object, you waive your right of raising an objection when you are on the cross.
Right. So because what we saw a press statement talking about this objection, and that is outside court. So it means this was not done in the courtroom; it was done outside through a press statement.
No, I think they filed a formal complaint.
Okay.
To the magistrate to investigate the process. And from there, this Cummings case is very interesting. Both sides issuing press statement all over the place. So after they filed the prosecutor misconduct complaint, then I think the deputy secretary of the ANC ran quickly and issued a press release to the press to say there's an investigation going on, and that the state chief, the man who called himself chief prosecutor, the Solicitor General, is alleged to have extracted, the Solicitor General and Mr. Jayweh extracted pertinent documents.
Yeah. So was this the first time they were seeing those documents?
No. They saw it during discovery.
No.
And they saw it doing, mind you, the two processes are different. We are no longer in the discovery process.
Yeah.
Where the state will pass on all of its documents in its possession over to the defense of Mr. Cummings, and where the name of the witnesses will be listed, books, everything they want to bring will be also listed for the defense counsel. We pass that stage. We are on a trial stage now, meaning that if this case should end today, Mr. Cummings could be convicted or not convicted. So the first witness for the state is the Theodore Momo, who is placed on the stand. Now, what the Cummings people did not do is that the prosecutor may hand over to Mr. Theodore Momo bunch of documents. So they should have objected before Mr. Theodore could say, yeah, these are the emails and the text messages and the WhatsApp messages. Because when you object, the court will give you a chance to review the document before Mr. Theodore can say, yes, these are the documents. If you don't object, you agree to them.
Thank you. There is a person from ANC we interviewed on this show, and she said, because the ALP leader took their private text messages as members of the CPP leadership and took those text messages to court, she's going to sue the ALP leader for doing that. Is the ALP leader wrong for doing that? Is he in error?
Anybody can sue. Anybody can sue. I don't know what she's talking about going to sue. I guess she may be talking about filing a lawsuit for disclosing the what you call it, WhatsApp messages, the chat room messages and whatnot. But let me tell you one thing: what ANC, what United Party, what Liberty Party, what other party, what ALP were in, was not a Zoe Bush situation. This was a business, a corporate transaction. So anyone who needs to know about what was happening in the CPP could file a petition for information, and the document will be given to them. In other words, this is not one of those documents that you can say protected. There's no special privilege there. So you can go sue. She can sue Mr. Jayweh, whatever thing she think, but she will lose in the. I guess you're talking about civil case. She may not have a favorable judgment in civil law court because what they were doing constituted corporate action, corporate association, meaning that the public had the right to know what they were doing.
So what you're saying now is at this point, Mr. Cummings cannot and his lawyers cannot object to this document. The time passed.
Well, no, it passed. Once the document was identified, you see, there is a difference between a courtroom lawyer and those people that call themselves corporate lawyers. The corporate lawyers, what they do, they don't come to court. They sit down in the law offices, work for Firestone, lawyer for Firestone, lawyer for Bond Mines, lawyer for Lamco, lawyer for LAC, lawyer for what the other one in Goodrich. All the companies, they support the activity of the company, and they get what they call a retainer fee, sometimes $75,000 per year, sometimes $100,000 per year. So they don't really know the actual trial proceeding in the courtroom because they are not encountering anybody. They're writing legal opinions for the company. They are defending the company's right to exist and the company's right to do business. But when it comes to a courtroom trial, you better know what to do in the courtroom, because any mistake that you make during a trial, it affects the interest of your client. I heard Councilor Cllr say that the document was voluminous. Some contain 100 pages, some contain 150 pages. So we didn't really peruse all of them. What? You are paid to be able to read all of those documents. You are paid to know the trial proceeding, to know when to object and when not to object. Their complaint is belated as far as I'm concerned.
Right.
The issue they're raising should have been raised by objecting and being allowed to review the document during the trial. Now wait until you get to cross-examination. At this stage, the government lawyer not doing anything right now. They leave Mr. Cllr to be questioned by them.
So what if, and I want to get into a hypothetical situation, what if they did this at the appropriate time and it was established that some of those text messages were extracted, some of those text messages that would have exonerated or that would have shown the innocence of Mr. Cummings, what that was established that those were extracted, what will happen then? Will the case be thrown out?
Okay, let me go back to what discovery is. The reason why discovery is had is the prosecutors and the lawyers for the defendant will meet with the judge in a conference, and they will both examine the document that's supposed to be used, and they will both agree that these are the only documents that are going to be used. The court will then secure those documents to ensure that documents through the back doors not coming in, or people not yet pulling documents from all over the place to be here to use it. Once the documents have been agreed upon by both the defendant and the prosecutors, and trial has started, you as the defense counsel don't put the first witness on the stand. It is the prosecutor that must put all of its witnesses on the stand and complete each witness that the prosecution completes direct examination with, meaning, Mr. Witness, what is your name? Where do you live? Is this the document that you just testified to? And once the witness says yes, when the prosecutor decides to present bunch of documents, I think that's what happened in this case, bunch of documents, told the witness on the stand and said, Mr. Witness, identify these documents. Are these the text messages? Are these the WhatsApp messages? Are these the email that you refer to? And the witness say yes. Then he will say, I pass you these documents. Please confirm and reconfirm these documents. When you don't object at that stage, because what the prosecution actually did was to present a bunch of documents. Right. How do you know that the document that you're saying were extracted are contained in that bunch of documents? And if they were not contained there, did you agree that by not objecting, you have agreed that those documents should be the only document used in the courtroom? So to answer your question, if it was established, if they objected on time, right, and then if they objected, they were then made record to ask the court to investigate. Because according to them, what they had in their hand is different after they went home and came back. What they had before during the conference and what the state had presented. There were discrepancies between what the state had presented. Right. Those text messages, according to them, that should have been in favor of Mr. Cummings were extracted. But the law is that if you did not object to the document and they were identified, mark, confirm, and reconfirm, it becomes part of the bunch of documents that the magistrate should look at, right, to establish whether you are guilty or not.
But if they were objected at the right time during that discovery process, it wouldn't even be admitted.
No. During the trial, we pass by discovery in trial. Right.
So my question is, if it is established now that those exchanges, some of them were extracted, what would have happened?
During the trial process.
On time.
During the trial process.
Yeah.
Yeah, during the trial process, if they objected on time, the court will stop and decide to conduct an investigation.
Right. And
if the court conduct an investigation and find out that those documents, because the court will have copy of the document, it'll be on the clerk file. When our magistrate, I will ensure that those documents that they're talking about, copy will be on my private file as a magistrate, as well as on the clerk file, so that I can be able to match them at the end of the day to be fair enough. If it was established doing that, then the court will set aside and have and investigate. And if the investigation established that the state prosecutor extracted documentation, that's not only lawyer malpractice. It violates the ethics of the lawyer. The magistrate will refer those lawyers to the Supreme Court for ethical investigation. And it could lead to you being suspended from the practice of law for 1 year. It could lead to your law license being revoked for 5 years. Many other things could happen to you.
But it won't affect the outcome of the case.
Well, no, and what the magistrate will do for fairness purposes, the magistrate will have those documents which he also has a copy, and the state will have a copy. The state as well as the defense lawyer have a copy. The magistrate would then, for fairness, allow the document to be used in court. The one that were extracted, because mind you, if the magistrate has a copy, which should be the copy that is, and I'm not sure he has that, but if the defense lawyer have a copy and the magistrate has a copy, and the clerk file show something different, the magistrate will say, then what is wrong here? How did these documents get to be extracted? And it will use the document themselves that they are claiming that were extracted. The court will have to use them, waive the technical part of it, and use them. But if you did not object,
right,
went through, then that's a problem. That's a problem that is on you. And if you claim that prosecutorial malpractice was committed, you will be required to produce the evidence. And you're not producing evidence from what you have in your hand because you waived that already because you did not object.
Thank you. Ladies and gentlemen, this is Focus on Liberia Justice Forum. I have Councillor Frederick A.B. Jayweh as the guest tonight. We are discussing criminal court versus the civil court. Before that, we are looking at the issues with the Cummings case. That is, the defense lawyer for Mr. Cummings are filing a criminal investigation against the state prosecutor. The next case I want us to look at here before we start our show tonight is the chairperson of the National Elections Commission has asked the judge of the Criminal Court C to dismiss the government's criminal indictment on grounds that the LACC, that's the Liberia Anti-Corruption Commission, violated the National Code of Conduct. Our lawyers argue in court that the anti-graft body, that's the LACC, violated the Code of Conduct when it took upon itself the responsibility of an ombudsman. So what they're saying is, this thing you're accusing me of, or the investigation you did, it's not you supposed to do it. It's supposed to be done by the office of the ombudsman. So you doing this, you violated the Code of Conduct, and so throw out the case. Councillor, what you see here?
You know what the defense lawyers are doing is supported by the Criminal Procedure Law, section 16.7. 16.71 to 4. 16.71 say defenses and objections which may be raised. Any defense or objection which is capable of determination without trial of the general issue may be raised before the trial by a motion to dismiss the indictment. What they are doing is that what the defendants are doing is they are saying, look, even though we are in court, there is an indictment drawn against us, and we are considered as criminal defendant. But Your Honor, do not go to the substance of the matter of this case.
Yeah,
we have a motion to file consistent with section 16.71 to 4 of the Criminal Procedure Law. And so what they did, they filed their motion. They listed the grounds. One of the grounds they listed, a couple of grounds. One of the grounds they listed has to do with the LACC could not be the appropriate agency of government to investigate the NEC if the amount of $182,000 that it claimed was inside trading occurred, even if it occurred. And so they're saying that the Code of Conduct gave this responsibility to a separate agency of government that is yet not set up.
Right.
The Code of Conduct says that agency should investigate inside trading and so forth. Now, let me add another thing. The Criminal Procedure Law, the substantive criminal law, the new penal code, is the Bible that defines all violations, all criminal offenses. In the criminal code, the penal code, there's nothing in there called inside trading. There's no law in the penal code that's called inside trading. So the defense lawyers are saying, look, this is not even a crime. This is not anything for which an indictment should be drawn. Because this, if it is anything that has occurred, it has occurred that it should be dealt with by an agency, a civil agency of government, to determine whether the action of Madam David Etta Brown Lasana constitute corruption or any other thing that inside trading,
Right.
that would be impacted. And so they are arguing in their motion, Your Honor, don't even touch the merit of this case. Don't even try to come near assigning this case from hearing. Now, let me tell you when that should happen. What they did was right after the defendant filed her bond. The next step should have been when they appear in court, I guess, for assignment, when they have selected the trial jury. The next thing was for the clerk of court to read the indictment to Madam David Etta Brown, and she was to plead guilty or not guilty. The defense lawyer did not wait for they called it a remand before the remand could have taken place to plead guilty or not guilty. They filed a motion to dismiss the indictment prior to Mrs. David Etta Brown Lasana, the chairperson of NEC, prior to she saying, I'm not guilty or I'm guilty. The law said that they can do that. Section 16.7, this is 2. It said, 2, I'll read that. Defenses and objections based on defects in the institution of the prosecution or in the indictment other than that it fails to show jurisdiction in a court over the subject matter or the charge of an offense may be raised only by motion before trial to dismiss. What they are saying is that the objection the defense just filed is consistent with law. It's in place. They can raise those objections before. Now, what I read in the Daily Observer was, and I'm disappointed with that. I read the Daily Observer raise a rhetorical question and saying, is the NEC chairperson going to be allowed to walk free?
And Councillor, we'll get to that. Mm-hmm. What I want to find out before we go there is the defense lawyer raised 2 issues. Number 1, say for you to investigate, there's an agency of government that should do this. LACC, you are none, and so you can do this. Number 2, in the penal code, there is no insider trading. So where are you coming from charging us with this, charging David Etta Brown Lasana with this one? Those are the 2 issues.
Correct.
What's the merit?
So the facts in this case indicate that legally the LACC ran faster than itself to have investigated a matter that had no jurisdiction. That's what we were saying is that, look, the LACC has lacked the legal jurisdiction, lacked the factual jurisdiction.
And the office that's supposed to do that does not exist.
Well, the lawyer, as a lawyer, if I'm defending Mrs. David Etta Brown or the NEC, I don't care what it is. I'm not the one that's supposed to establish it. It is a responsibility of the government, but the law says that it should be established, and it is in our law. But what is interesting is that the defendants are saying this is not a crime at all. Even if the NEC chairperson committed the offense that you're talking about, it is not a crime because the new penal code does not define it. So where did you get your indictment? On what procedural law? You know what I watch? Some of us who went to school a long time. I watched the prosecution in Liberia now. I mean, the prosecution in Liberia, some of them, the lawyers can basically choose any form of crime. Many judges will just bring in one indictment. Now, all the defense is saying that if it is true, the merit, which I believe legally is true, that the merit of this case should have been investigated by the government agency that is not yet established, but that should have been established. And not the LACC. The fact that the agency is not established does not mean that the power to investigate rests with the LACC. The law does not pass the responsibility over to LACC or even to the Minister of Justice. Besides, the insider trading is not part of our law, our criminal new penal code. It is a new penal code that defines the crimes for which prosecution can go on.
Right. But insider trading is just one. There are other crimes that are defined under the penal code. So why would you throw everything out because there's one there that is not defined under the penal code?
Well, no, the argument is that they believe that the matter was started the LACC procedure by wrong rule, entertained and heard, got report, drew indictment, went to court when it had no business doing that. Like what they are saying is that in a civil case, the government of Liberia, unless it is a party, unless it files a motion to intervene, because its interest might be at stake, the government of Liberia has no responsibility in such cases. If public official misbehave, it is defined consistent with the code of conduct, not by the criminal procedure law, or not by the criminal code. And if it's not in the criminal code, it doesn't exist. It's not a crime.
So who investigates the code of conduct violation?
Well, the agency that is not established.
It's not established yet. So where do we go from here?
I don't know what the judge would do, but if I'm sitting as a judge, I would dismiss the matter because I like jurisdiction. This is a civil matter. You got no business coming before me as an indictment. And if they want to, they think there's a crime committed, you can proceed. The other thing I wanted to add is that the dealers, everything you said we should wait a little bit.
Yeah. Dealers ever say, can she walk free?
The dealers ever say, will she walk free? That kind of headline seems to misinform the people of what the facts are and the controlling law. Let me go down to 5. The effect of the determination of a motion to dismiss. It said, if a motion is determined adversely to the defendant, he shall be permitted to plead if he has not previously pleaded. A plead previously entered shall stand if the defendant has pleaded. If the court grants the motion based on a defect in the institution of the prosecution, in this case, that's what they are saying. They said there's a defect in the institution of the prosecution or in the indictment. It may also order that the defendant be held in custody, or that his bail is continued for a specified time pending the filing of a new indictment. So the fact that the court dismisses the indictment for lack of jurisdiction, for lack of formality, lack of the institution, the proper institution of prosecution, in many cases the judges would decide to give the prosecution chance to go and find a new indictment, have the defendant rearrested on a new indictment. But because in this case the defendant has a bond, the bond will be allowed to stand, the defendant will be allowed to go, and then the prosecution will start all over. So the court could do this. So for any journalist to write and say, make it to look like when this indictment is dismissed, that's the end of the case, it's just fallacy. It's a legal fallacy, factual fallacy, legal fallacy.
Okay.
You don't write that.
And here is what the dealers ever said. Could NEC chair go free on technicality? You are saying even if the case is dismissed, the prosecutors can be asked to do a new indictment.
The judge on its own may, the law says the judge may decide if it is a case that the defendant is supposed to be in prison while the case is going on. The judge may continue to hold the defendant in prison, order that she remain in prison. If the defendant has filed a bond, the judge will still say that the bond will remain, and then give the prosecution chance to go and bring the appropriate indictment. So it's just not walking free automatically. If the judge doesn't do any of those, in order to make such a statement, you must wait until the judge has decided that the indictment is dismissed. The judge does not add anything to say that the defendant will still be held by the court and the bond will continue as it is, you can't make that statement that the judge had determined that. What I know is that when an indictment is dismissed in Liberia, the prosecution has, that's one ground the prosecution has to appeal to the Supreme Court. So an appeal could stay the judgment of the court below, which is criminal court C. All of that is a process that you need to understand in order for you to write and say that this person may walk. But if the state does not decide to announce appeal, then the person may walk, and the judge did not specify that the prosecution had 10 days or 2 weeks to bring a new indictment, then the defendant may walk, but you cannot, or rather say the defendant will walk without understanding all of the technicalities.
In this case, who's the prosecutor, the LACC?
Yeah, what is interesting here is that the LACC, the statute that created the LACC, requires that the LACC can investigate matters of economic, economic crimes,
right,
economic sabotage, and so forth. But when the LACC is done, it should refer the matter to the Minister of Justice to determine, to have the Minister of Justice prosecute it. It doesn't get up by itself and begin to prosecute. It must deliver the entire findings and everything to the Minister of Justice. The Minister of Justice had 90 days to decide whether it will prosecute or not. And if the Minister of Justice at the end of 90 days does not say anything, then the right to prosecute automatically revert to LACC. But the LACC doesn't get up and run to go prosecute. This is an interesting matter because this is one of the matter that the LACC was so, as the Liberian people say, so hot to go to court that it did its own investigation. Right. It went to the court, was able to get an indictment. It got a writ of arrest. It also made sure that the court officer went out to arrest Mrs. David Brown Lasana. If I were defense lawyers in this case, I would go to look at how the indictment was obtained, because the criminal procedure law provides that the list of witnesses that appear before the grand jury that testify and say that there's a probability that a crime was committed, the list of those people should be listed, should be part of the notes of the indictment. Then the foreman of the grand jury that sat and heard the case presented by the tribe, by the LACC, will also have to sign. The minutes that were made during the grand jury proceeding will also be available to both the defendant as well as to the prosecutors. If those things are not available, I will object to say that this is a fraudulent document. And so guess where we're going? The government will just be laughed at. Whosoever that encourage the LACC chairperson to become so super hot to run to court will be ashamed.
I think the LACC was, I'm not sure, but there was a request to give them prosecutorial powers, and I thought that was granted already. Not yet?
I think I heard the president saying, I think when he participated in the United States Democratic, some kind of meeting that went on when the U.S. government invited countries, but Liberia, one of those countries that are invited. And the president said he was going to work with the House of Representatives and the Senate to give them prosecutorial power, as that they could prosecute cases by themselves. I don't know whether the president understands that or not. What that does is that it creates a clash with the authority of the Minister of Justice to prosecute. The Minister of Justice in Liberia is the sole agency of government that must prosecute all criminal cases. That's the only agency. So if you give equal power to prosecute criminal cases as a Minister of Justice, is there a constitutional issue there? There might be.
Thank you. Ladies and gentlemen, if you're just joining us, this is Focus on Liberia Justice Forum. We are discussing the two cases here, the Cummings case and the David Brown Lasana case. Our topic for the day, which we are about to just get into, the courts of Liberia. This is just part one, and we want to talk about civil courts versus criminal courts. For the 30 minutes we have left for this show, we'll try to squeeze this in and continue part two next Sunday. Councillor Jayweh, let's look at civil courts and criminal courts. We want to look at those courts that make up the civil codes or criminal codes, what they are, what their functions are, and how these are different.
So let me talk about the civil codes first.
Okay.
So in Liberia, the court system are divided up into circuits. In Monrovia, it is called the First Judicial. We're talking about civil. In Monrovia, there is the Sixth Judicial Circuit Court, Civil Law Court. So those that divided up the court system decided that all civil cases, now they got Civil Law Court A and Civil Law Court B. Before it was just Civil Law Court. Cases like divorce, cases like action of damages for breach of contract, cases like declaratory judgment, cases of injunction, defamation of characters, and all civil cases where money in judgment will be sought. Ejectment, kicking somebody off your land, eviction, kicking somebody out of your house. All of those cases in Massachusetts County will be filed before the Sixth Judicial Circuit Court, Civil Law Court. That's the name of the court. So all civil cases went there. Now they have Civil Law Court A and Civil Law Court B. Only civil cases go into the Civil Law Court. It's only one court, it's not two courts. But before it was only one court called the Sixth Judicial Circuit Civil Law Court. All civil cases must go there. So then, so there could be now that assistant in civil law court to handle those cases that just some of the cases that I just named, and they all has to be civil cases. The government has little or no right in it unless they file a motion to intervene and what they call an intervener answer, an answer to the complaint. That's when the government, other than that, government may have little or nothing to do with it. Then, so that's one court. The civil law court is A. They got B. So there are two courts now for all of the civil cases. They established recently the commercial court, business transaction, commercial court dealing with business transaction. It's also a civil court, a civil law court, but it deals with transaction between business owners.
So the civil law court A and B, what's the difference?
So A, hearing cases that dealing with breach of contract, hearing cases of actual ejectment, hearing cases of divorce, hearing cases of declaratory judgment, petition for declaratory judgment, all civil cases, except that could be, it's almost like could be is an assistant to civil law court. So where the cases are too many, some of them go to court B.
Okay.
To ensure that the docket is not crowded. So the B court A and B will civil law court A and B will share the cases, so that the docket cases cannot just remain pending on the docket. Now that's the civil law court. And it's a direct general trial jurisdiction court, meaning that all civil cases that which you're asking for money judgment and so forth will go to the civil law court A and B. Then there are the specialized courts. So
before that, then what is this? You say the circuit court. So the circuit courts are civil law courts, or
so let me jump into it, but let me name. So Liberia has First Judicial Circuit Court. Okay. So I think now 16 Judicial Circuit Court. So meaning that in each county there is a general trial court. So for example, Bapolo is a 16, I think 15, it's a 15 Judicial Circuit Court. Kakata is a 13 Judicial Circuit Court. I mean, those that wrote the new judicial law, they decided to have courts in all of the counties that Liberia have. I think Liberia got 16 counties now, right? 15?
Yeah.
Okay, so Bapoli made it 15. So in each of the counties, there is a court. So because the settlers that found that called what they call found in Liberia, most of the things were happening in most of our counties. So there's a First Judicial Circuit Court, which is, if you're talking about criminal cases, criminal court, First Judicial Circuit Court, criminal assassin's A, B, C, D, E, all of them in Mosurado County. But the court in Grand Bassa County, because they said Grand Bassa County was the second county to be added to Liberia, Grand Bassa County has a second judicial circuit court. And I think the third judicial circuit court is Sano. So as the county were added, they were calling them judicial circuit court. But all of the counties in Liberia, the 15 counties in Liberia, have 15 courts. Now, the difference between Mosurado and the other counties is that in each of the outside of Mosurado, the courts that in those counties, take for example the second judicial circuit court in Grand Bassa County, that court can sit as a civil law court, can recess itself and sit as a civil law court and hear civil cases. Because we don't have civil law court separate in Grand Bassa County, in all of the other counties. So in Sano County, the circuit court sitting in Sano County, third judicial circuit court in Sano County, can also hear criminal cases and civil cases. The same judge. But all the judge would do, he would say, and then all criminal cases must be heard in the morning hour. 9 o'clock, some judges can go to court very early, 8 o'clock to 12. From 1 o'clock to 4 will be civil cases. The province, the priority for hearing criminal cases will be like in the morning. All the civil cases will be in the evening. But because we don't have separate civil law court in those counties, the judges in those counties, Sano, Grand Cru, Maryland, Grand Jida, River G, all the rest of Bapolu, all the Lofa County, Nima County, those judges will be required to sit as judges of civil law court, criminal court, as well as sit as judges for criminal court. So they hear criminal cases as well as hearing civil cases. So there's no separate judge hearing the criminal cases and a separate judge hearing the civil cases. So all of the duties performed by civil law code A will be performed by them. Civil law code B will be performed by them. In their situation, they're doing A and B together.
Wow, is that dangerous or not? What's the risk?
I would say yes, it's dangerous in that the judges in Liberia, which is sad, they do not have law clerks. So they are expected to do their own research. They are expected to sit in court and hear the cases. They are expected to go ahead and write the decision. They are expected to go ahead and deliver the decision. It's I've been to Greenville. I was in Greenville. I had a case in Greenville, and I was in Greenville. I slept there, and the next morning I went to the courthouse, and there was no clerk, there was no judge. So my question was, I asked on the court officer, I said, my name is Councilor Jayweh, I have a case here, and I came to court. And the clerk said to me that, the judge going on his farm. And then I said, but where is the assistant clerk said to me, the judge is going to go on his farm. I said, oh, what is the clerk? He said, clerk also, I think he's going to his farm. But the case should be by 10 o'clock today. So well, maybe we'll have to call the judge and the clerk. And that was not only happening in Sano County. It was also happening frequently outside of Monrovia. If you want to Grand Jida, it will be almost the same thing. If you want to River G, it might be almost the same thing. If you want to Kakata is much closer. It will be a little bit better. If you want to Banga, it will be a little bit better. But if you went into Lofa County, in fact, on one occasion, I had to carry bags of papers because the clerk told me, Councilor, we don't have paper to hear the cases here. So in other words, what I'm saying is that in all the judges outside Mosurado County are required to hear all civil cases as well as criminal cases. It's a lot of work, and so justice will not be done to people. People's rights could be violated. The cases will stay long on the docket. Some people will die before the cases can be heard. Sometimes the cases are not heard at all. So they have from first judicial to 15 judicial. We got 15 counties. So there's a code sitting in all of them. And though the same word that code A, B, C, D, E, criminal code A, B, C, D, E will conduct, they are required to conduct them. And because again, I one time said I would hope a lawyer will get elected as president of Liberia. Reason for that is that the judiciary is taking advantage of in terms of the budget. If you talk to the Chief Justice, he'll tell you we don't have sufficient money to be able to have law clerks. And so the judges are supposed to be doing everything, law clerk, research officer, judges, hearing of the facts and whatnot. And it's been like that since 1847 to now. So we have all everything else is outside the content of Maserati. The courts are performing the duty of code A, B, C, D, E, criminal code A, B, C, D, E. And I'll tell you what A, B, C, D, E. And in Maserati County, there's a separate code set up called criminal code, civil law code A, and then civil law code B. And all civil cases will go there. The thing that is good to understand is that no arrest will be done in any of these civil cases. They will go on. There could be judgment by default, meaning that the defendant did not appear, and the court enter a final judgment against him or against the corporation, something like that. Now, criminal code. Let me talk about criminal code A. A is supposed to hear all murder cases. Could be supposed to hear criminal mischief, arson cases where you put fire on somebody's house and the house got burned.
No, we're talking civil court. So if you want to start with criminal code, then you got to start from the top.
So all what I said prior to calling code A, B, C, all the civil courts that in Liberia, for example, in Maserati County, is different because there's a civil law code A and civil law code B. So you hear all civil cases. All cases that that will be requiring money judgment, eviction, and so forth. There's no arrest in it at all. But I'm saying the disadvantage with Maserati and the rest of the county is that Maserati County has civil law code A and civil law code B. In the rest of the counties, the judges are required to sit as judges hearing civil cases as well as hearing criminal cases. And where there are no special high court, we get to the special high court. But and so the thing about it is that in all of this, the defendant will be summoned to come to court. The defendant will not be arrested. If the case go on, it can be an ejectment suit, action to evict somebody from somebody's land or to evict them from somebody's house. The civil law could hear all of those cases, and they render judgment without the intervention or the participation of the government of Liberia. That is not so in criminal cases. In criminal cases, the government of Liberia is the plaintiff, and the prosecutors, including the Solicitor General, will be the lead prosecutor in all of the criminal cases. There will be arrest. There will be the filing of bond. Some liberty of the defendant will be restrained. For example, we heard the other day Mr. Cummings was to travel and not to travel, was to travel and he could travel. Again, it's controlled by the court. Several cases, the judges don't manage who leaves and who comes back. So if you and that's about civil cases. And what I'm saying is that outside the county of Maserati, those judges in those counties, the 14 counties outside of Maserati, must act as civil judges to hear all civil cases. Now, if we're talking about criminal, I will talk about criminal cases, criminal code now. The criminal code that we have in Liberia, particularly in Maserati County, is criminal code A, B, C, D, E. So A is supposed to hear cases of treason and so forth, murder and all of that. B should hear you want to burn my house or you put fire on my house, arson cases. Code C supposed to hear theft of property, economic sabotage cases. Right. Code D, armed robbery cases. Somebody use knife, gun, or whatsoever to come to a house, whether in the day or in the night. Code D hears that. Code E, sexual offense cases, rape, all of those kind of things. But in Maserati, code A, B, C, D, and E are not sitting to hear any civil case. They only hear criminal cases. The disadvantage is outside of Maserati County. All of the judges in the rest of the 15 counties are required to hear both civil cases and criminal cases. So they have more work to do.
And the reason for that is because there's no money?
Well, the argument has been there's no money to be able to establish separate. They have started to do something about it because I know that they have started to establish debt courts, which is outcome by the special high court, so you can to pay some attention to it. They started to, before those courts were hearing all the civil cases that they named in the civil law code, civil law code A and B, and they were hearing death action. They were hearing divorce cases. So there is no separate divorce code in any of the counties.
Right. And the judges that are appointed to those courts, A, B, C, D, and E in Monserrato, do they need specialized, because one is hearing murder cases, another one treason, another one economic sabotage. So do you need a specialized training to be a judge in each of those areas?
You need to be a law school graduate, maybe from the Louis Howard Graduate School of Law, and you might have practiced law. In my time, it was like they were required to practice law for 3 years. I think it's now 5 years. You must practice as a private lawyer for 5 years to gain experience. The thing that is interesting to note is that all these judges, Liberia is a general trial jurisdiction country, meaning that all judges, the Supreme Court rotates the judges. So you were in for 42 days. So you were in criminal code A for the May term of court, meaning that in May the court opened and you were assigned to criminal code A. You stayed there until we got to the August term of court. You could be moved to criminal code B. So you are expected to know the law all over completely. You are not just confined to criminal code A, hearing cases that had to do with murder, treason, and whatnot. You're supposed to be able to know the law on arson. You should be able to know the law. Let's say you were taken from code A to code E, sexual offense cases. You must know the law on rape and what constitutes sexual offenses. So in other words, you learn the law in a general manner, you should be able to apply it. So that you're not restricted to any specialized, you're not a specialized person. You're going all over the place. It's a general, yeah, it is, because not all lawyers would be very smart to be able to know the law like that. In fact, the people who call themselves corporate lawyers in Liberia are people who will say, I don't want to have anything to do with criminal law. So you don't, when they have criminal cases, they look for lawyers who know criminal law to handle those cases. And if one of them get to be judge, then that's a problem, because that guy has confined himself only to corporate cases and not into general trial processes. So you don't need to have a special. I mean, I think because of money, they say there's no money, and I'm saying that if we were to get a lawyer to be elected as president who have practiced law sufficiently and know how the judiciary function, you will see that the budget, you will not be giving the judiciary maybe $20 million as a figure in the budget to run the entire judiciary, the entire 15 courts in Liberia. I think there will be any money higher than that. I would not understand why would the Minister of Justice get between $80 million to run a Minister of Justice when the judiciary getting less than $30 million. I don't understand that. I don't know why the Minister of Finance would get $210 million as his budget, and the judiciary get less than $40 million. I don't know what the Minister of State for Presidential Affairs will be today. I will speak. The Minister of State for Presidential Affairs is asking for a budget of $23 million. I think I need to look at the budget figure again, but it's around 20. How would one person who is a Minister of State for Presidential Affairs has money in the budget more than the judiciary, which is a branch of the government? The third branch of the government. Why? And why would the Ministry of Health will have pretty close to $69 to $72 million when the judiciary had less than $40 million? I could go on and on and on. So that's why you have the judges in those counties hearing, they decide to hear cases and don't. It should be interesting if you went to those courts outside of the city. The judges, at my time, the judges were so much having little or nothing to run the court, to the point that I just said to you, I had to carry 1 or 2 boxes of paper from Monrovia to one of the court system to be able to have paper to use. At some point, the judge was telling us at the time they were using Cllr. The judge was telling us, my Cllr broke down a long time ago. And so you were asking the clerk to take minutes writing, using pen and paper to write. So the judiciary is the least treated, in my mind, it's the least treated agency of the Liberian government. Why would one judge hearing all the cases, all of the different cases, Why is that judge in Sando County allowed to permit it or even coerce? I would say coerce, not even permitted. Coerce to hear criminal case, civil case, divorce cases, ejectment cases, everything else. How many of those cases can he do within 42 days?
Right.
He can't.
Especially for a whole entire county.
Of course, he can't. So the political, my contention has been the political people look at the court as a no-use branch of the government. And if you want to know, as I speak to you, judges are making under the weird government $2,500 per month. A judge in Calcutta who graduated from law school with me, I spoke to her and she said to me, "Counselor, don't come here to work. I'm making $250 a month, $2,500 a month." And an assistant minister or a senator, or what you call it, a representative, can get pretty close to $7,000 a month, or even more than that. Ellen Johnson said it, I think, like $10,000 a month.
The judge is making. Oh, wow. Let's take a break and then we'll get questions. There are a lot of questions on the even the first issue we're discussing before we get to this. So let's take a short break and we're going to be right back. Ladies and gentlemen, welcome back. This is Focus on Liberia Justice Forum. We are dealing with criminal courts versus criminal courts and civil courts. Let's read our comments. This one from David Cooley. If it is true that text messages were selective, thereby leaving out other texts, can the court throw out the entire text messages? At what point does the court consider evidence to be, I think he's considered, or maybe admissible, maybe? What's your response, Counselor?
So as I just said, is that I think there is a legal impropriety here from the competence here on the part of the Cummings lawyer. I think that they failed to object when they were to object. That would have allowed them to be able to review a bunch of documents that the state prosecutor presented to witness Cllr Momo. The failure to have objected when the objection was necessary or required by law is referred to as a waiver, meaning that the right to contest whether document was extracted or not. You already lost it. So the magistrate will be required to look at only those documents that have been identified, confirmed, and reconfirmed, and nothing else.
So hold that thought. David comes back and says, I thought it is usually during examination and cross-examination that evidence authenticity are done. At any point during criminal investigation, when the defendant see or discover that there is incorrect evidence, the defendant has the right to object. Remember now, in order ANC leader to be convicted in criminal, the law must meet the threshold of conviction beyond reasonable doubt.
Yeah, so I can answer him again that he understanding, I don't know what is his understanding, examination and cross-examination. On an examination process, the state lawyer witness on the stand, the state would then take the stand as the first party in the trial to put its witnesses on the stand. The state will have to ask the witnesses question, ask the witness to identify the documentation, and mark and read what you can mark, confirm, reconfirm. When that witness, when the state is done with asking, doing direct examination, giving the witness chance to confirm the document he or she testified to, Then the prosecution, the defense counsel, we begin to ask questions, cross-examine. That's when cross-examination, general questions are asked to ensure that the witness testimony can be torn apart, to present to the court that the witness has in fact lied instead of telling the truth. But if you did not object, which is a trial procedure, if you did not object to pieces of document that were presented to the witness, and those documents were identified, they were marked, confirmed, and reconfirmed, meaning that it's the same document that you look at, you say, well, the Constitution, like, here is it. It said the same Constitution you're talking about, the witness say yes. The lawyer asked the court, at this stage, Your Honor, we ask for a mark of confirmation to be placed on the document. The judge will order the clerk to enter a mark of confirmation on the document. You have lost.
David is basically, let me read a few of his comments before you continue. There is no limit to the discovery process during criminal trial. Even in the United States, during criminal investigation, both prosecutors and defense attorney can introduce new discovery.
Well, this is not, in Liberia, it's a different thing. You're talking about, what he's talking about is newly discovered evidence. When doing a trial, there are newly discovered evidence. The defendant, the lawyer for the defense, or the defendant, in the case of Mr. Cummings, may move the court to introduce those documents that they thought were necessary, but that were not part of the discovery process. In Liberia, when discovery ends, we're not going back to discovery. We're on trial. So we don't flip between both of them. You don't flip between discovery and trial. So what they own right now is a trial proceeding on the merit of the case. If Mr. Cummings, if this case should be determined adversely to Mr. Cummings, he will be convicted. If it's not determined based upon the fact adversely to Mr. Cummings, will be let go. And then the government of Liberia may decide to announce appeal. And the appeal will go to the circuit court. This time it will go to criminal court A. And then may travel on to the Supreme Court. So that's a long process. What is surprising to me is that this case is running the clock out. And if we are not careful, this case may run into 2023. Because all of the objections, all of the complaints are being filed along the trial, set aside the actual trial and an investigation that will go on. What if the magistrate does not assign the investigation next week, any day next week, or assign it 2 weeks thereafter? Look at the time that is being wasted. So
it's by design.
Yeah, the thing is in cases like this, you can have very young lawyers who are smart, able to go to court and whatnot, but a very seasoned, experienced, old-head lawyer has to be up there with him, because there are things that need to be done. If you don't do them, you cannot do them any longer.
G. Gwen John Smith, the SG can be running his mouth all over and even already commented on the penalty Cummings will receive.
I think the FG, I think he's in a drama. I think he more like unprofessional to stand. I've heard him, I think I think it was last week or a week ago, telling the press when we'll see what you call the school, Jayweh Gibson. When will Jayweh Gibson open, because we won't finish with the case for Mr. Cummings to go there and start teaching the small children. That's what he was saying. That is more prejudicious. That is a violation of every ethical proceeding. That is ensuring that you are imputing politics into the legal process. That is, people could think that Mr. Cummings is haunted. Why are you making this decision? Are you the judge? The first witness just understand you saying that Mr. Cummings will go to Jayweh Gibson to teach?
Why Jayweh Gibson, people?
I don't know. Maybe he went to Jayweh Gibson as an elementary or junior high student. So he wants Mr. Cummings to go teach fairness in the school. You don't make such a statement while the case being tried. Because it's like you're saying that we the prosecution, in discussion with the judge, that we will win, and we're saying Cummings to go teach. That's what you're saying. When the judge may not know anything about what you're talking about.
Yankwe Boma say this lawyer is wrong. Counselor Yankwe say you are wrong. Yankwe, what is he wrong about, please? clarify so the lawyer can respond. David Cooley's also saying, I don't see anything wrong with the Daily Observer headline looking at the language used in the head. The Observer is not making any emphatic statement. So the lawyer is asking a question.
Yeah, but they insinuating that the defendant may walk.
Okay. Ivy Tyler says if the judges and lawyers are so poorly paid and courts barely equipped, it leaves them at the risk for bribery. He who has money can easily compromise a case. Is from your experience, is that what happens?
Well, I don't know whether she's saying lawyers. I don't know why you put lawyers in there because we're different. We can charge our client fees before we go to court. So I'm not saying lawyers are poorly paid. I'm not saying that. I'm saying as far as I'm concerned, the judges currently in Monrovia, in Liberia, not even Monrovia, are being paid $2,500 a month. It opens the door for people to influence the judges. And I have said that if I were in Liberia for a very good while, we will sue the weird government, the executive branch of government representing the judges, to ensure that Article 73, which says that, 72, I guess, which say that the salaries of judges are not to be reduced. We sue them and require that the judges either return to the salary they were making in the Sally Johnson government time, or that the budget be readjusted to ensure that judges are paid. If you don't pay the judges, you open the door for people to bribe them.
Yeah.
And considering that Liberia is a very, very bad place in terms of people being poor, how do you prove bribery? It's very difficult to prove unless you like Vanny Sherman, that they catch you in trying to bribe people.
Talk about Kwe say the Solicitor General said demonstration school, not G.W. Gibson.
Okay, it doesn't matter about what school the case will be going on. You say you go to demonstration school to teach. To teach what? Are you the judge?
John Maulo says, does the counselor know that the document given to the judge was different from what was given to the defense lawyer? If the lawyers didn't see that the judge had, if the lawyer didn't see what the judge has, how could they object?
Okay, the document is actually part of the court record. It was the clerk. The clerk is responsible for all documents that the court will be using in a criminal trial. So the lawyers were there when the testimony, when Mr. Cllr testified. The lawyers were there when the prosecution presented the document over to Mr. Cllr to identify, confirm, and reconfirm. They were to object. The excuse that the document were 150 pages, 100 pages, make no sense legally to me.
What John is saying is the lawyer that was given, the document that was given to the judge was different from the document given to Mr. Cummings' lawyers.
The judge doesn't have any file on his own. The file is a court file.
Right. So, but the point here is are these two different documents? The one given to the court and the one given to the defense lawyers.
So if the defense lawyers say they say what they saw before is not what is they now have in their hand to do the cross-examination. The document in question came directly that the prosecution was now asking to be identified. If it did not correspond with the court, that's why the court will go ahead and conduct an investigation. But again, I'm maintain that if you sat there, the document came through the discovery process, it came through the trial process, and then you did not object to it, they become part of the evidence that the court will have to pass on to determine whether Mr. Cummings is guilty or not guilty.
You said that two different documents, the one that came through the discovery process and the trial process is different from the documents that the Cummings lawyers have. I don't know how they will do that.
That's what the Cummings lawyers are saying. They are saying that what they saw on the discovery process is not what they are seeing now. So they believe that Mr. Jayweh, as well as Solicitor General Sifos, may have extracted those WhatsApp messages. Right. But the investigation will cover that. What I'm saying is that all what a smart trial lawyer would do and will do it to an inexperienced lawyer, will be to hand a bunch of documents to the witness and say, these are the documents, name a few of them and say, these are the documents you just testified to, identify them. All he's doing is that he's covering, he should be able to identify, for example, the text message from May to June is page 1 to page 10. Mr. Witness, look at this document and say that these documents say that these are the same document that you testified to. He will separate them, put them into a special column, but he didn't do that. He decided to look at the incompetence of the Cummings lawyer and say, Mr. Witness, these are the documents you testified to. Look at them, identify, confirm, and reconfirm them. And at that level, the Cummings lawyer should have objected. That would have given them sufficient chance for the court will say for them to review the document. If those documents are marked, confirm and reconfirm, you don't have an objection to it. The complaint you're filing, you have to prove that the document were extracted. And all the prosecution would do, they will object to you bringing any other document beside the document that have been identified. That's what will happen. And at the end of the day, you lose because you don't have a proof.
We've said a lot of things on this case, Counselor. If you look at in total, Cummings is in a very tight position. Will you agree?
Oh yeah, I think as I said, Mr. Cummings is in a very tight position. The thing about it is that I don't know how much merit Mr. Cummings attached to this case. Meaning that this is not a case that you can ask a very young law school graduate who became a counselor of law to handle. This is a case, if you want a young person like that to be part of it, you also need to have an old hand, somebody who knows the trial proceeding very well, to be present in court.
These guys are from Counselor Nimbali, one law firm, so I don't know why. Is he not part of them?
Well, no, Nimbali one is a corporate lawyer.
Okay.
Meaning that he goes to court, but he doesn't go to court frequently. It's easier to go before the Supreme Court. You know why? Because in the Supreme Court, you get all the record, the Supreme Court get all the record, I mean, the photocopy of the record from downstairs taken to the court. And all you do in the Supreme Court, you file a legal brief. And then you stand up there and argue. You're not, there's no procedural thing in there. You're arguing why the court should confirm the judgment that will enter in your favor. In the trial court, it's different. The actual trial, the actual proceeding of the case goes on before the trial court. When is a document identified? When is it marked? When does it become accessible to become part of the evidence? If you miss all of those, you have a problem. And you can't, because you are a Supreme Court lawyer, does not give you any kind of edge over anybody who is a general trial lawyer. Because a general trial lawyer will know all of these things. He will know when to object, when not to object. And when you object, the court will ask you people to argue. And when you argue, when the court grants your objection, they will give you the document to review and say, oh, look, the July, I think they said something from July to something, from May to July, something. The document, I think, is made that. Your Honor, these documents were part of the discovery process. They are no longer there. But he didn't do that.
Yeah.
You sat down, you allow the Solicitor General to go through that. Then you say, oh, Mr. Jayweh extracted, Mr. Jayweh and the Solicitor General extracted that. Is that a legal statement or a political statement? Because if it's a legal statement, then you have to establish that Mr. Jayweh was part of the extraction.
Thank you. Maurice Sekou Kana say, I'm watching from Philadelphia. Monica, hey family. Councillor would read some announcement here and then we get your closing comment. Tomorrow, Monday, we're going to have an exclusive interview with Max Mixer. That's Ambassador Maxine S. Bakio. He'll be joining us from the UK. And the issue we're going to be talking about, he's spent 2 years in Liberia. We'll talk justice issue, his 2 years stay in Liberia, and he's being petitioned to run for the House. All that right here on Focus on Liberia tomorrow at 7 p.m. and 12 p.m. GMT. And then Tuesday night, we're going to have revenue generation and job creation in the mining sector, the case of Asala Mitar. My guest, Dr. Kama Maluba, is a former mining engineer, production and great control at your mining company. The time, 7 p.m. Tuesday night. Wednesday, we're going to have auditors and auditing in Liberia, the case with Robert Neal and the IAA. Robert Neal will be my guest on Wednesday night to discuss auditors, auditing in Liberia, and he's not been in a very good spot with the government of Liberia. I think he has a tenured job, and yet he is being fired. Robert Neal will be here, and we're going to have that discussion. You don't want to miss that. Councillor, we cover a lot of ground. Let's get your pattern comments and set the stage. I think we're going to continue with this court next week because we didn't even touch specialized court. So we're going to continue with the courts of Liberia next week, right here on Focus on Liberia. Councillor?
Well, yeah. The only thing I have to say is very important for our people to not have a preconceived mind or minds before coming to this discussion. Pay very good attention because it's intended to help you. For example, we want you to know the difference between the functions of the civil law courts and the function of the criminal courts. We want you to know what the judges are experiencing outside of Maserado. We want you to know that lawyers have responsibility to be able to defend the client. That's why they are retained. That's why they are paid. We want you to know when people make mistake in the law, what happened to the clients. You may not like it, but at the end of the day, a mistake in the law is no excuse. It impacts your client. So as we go along, we get to much more explain what the specialized courts will do as compared to the criminal courts. These are interesting topics to be able to bring the court system of Liberia to you who are not lawyers to be able to ask the question. And if you have political minds, you will not be able to get what we are doing. Thank you very much, and thank you for your time.
Thank you so much. Okay. We want to thank all viewers and thank you, Councillor, for coming and always to be here and discuss these things. We encourage all of you, lawyers and non-lawyers, please watch. And if you want to be a part of this discussion, please don't hesitate to call me or contact Councillor Jayweh or Councillor Kabineh Janen so that we can discuss this. We want to say again, thank you. We'll look forward to Monday. The entire next week is packed with shows right here on Focus on Liberia. I want to announce to you that we are getting, or I would say we are under tremendous pressure to extend Focus on Liberia to Liberia, to have a radio station. We are working on that, and we're going to be coming to you for your support so that, because by this time, there are a lot of people who want to listen to and watch these discussions, but it's late in Monrovia now in Liberia, and they are in bed. Yesterday, people tried to stay up to watch the history of Liberia, but some went to sleep before it started. So we are working on establishing a radio station that will broadcast throughout the length and breadth of the country, and will be coming to you for your support. At this time, we want to end the broadcast, but we never leave without playing our song that says, "We are all Liberians." Whether you believe that everything that we have said here is true or not, we are all Liberians. No matter, or you come to this discussion with a political mindset, we are all Liberians. What is incumbent upon all of us is to do everything we can to make Liberia the glorious land of liberty. Good night, and God bless you.
We are Liberians. Liberia is our home.